Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 148. There were two issues before the Honorable Bombay High Court in the present case. The first issue was that if the addition of the assessee has already been made under section 143 subsection 3, for which the CIT appeal has already given the relief to the assessee, so whether on the same issue the assessing officer can issue the notice to the assessee under section 148. And the second issue was that whether the assessing officer is bound to follow the decisions of the appellate authorities and the jurisdictional high court, and if he does not follow those decisions, then whether it will come into the category of abuse of power vested in the public officer. These issues have been taken up by Honorable Bombay High Court in the case of Samp Furniture Private Limited versus Income Tax Officer and others. This case is reported in 477 ITR at page number 187, and the date of the judgment is 5th August 2024. The present case relates to the assessment year 17-18. In the present case, the assessment of the assessee was already completed for the assessment year 17-18 under section 143 subsection 3, which was the year of demonetization period, and the AO has made the addition of rupees 4 crore for the cash deposited into the bank account, for which the CIT appeal has already given the relief to the assessee in the appeal filed by the assessee against the order under section 143 subsection 3. After that, the assessing officer issued the notice to the assessee under section 148 on the same ground. The assessee filed the replies before the assessing officer in response to the notice under section 148A clause B, because that procedure was followed by the learned AO, and the assessee apprised the assessing officer that the same issue has been covered by the assessing officer earlier, for which the CIT appeal has given the relief, so it is not a fit case to issue the notice under section 148. The assessee also took the plea that since the jurisdictional assessing officer has issued the notice in violation of section 151A, read with notification issued by the Central Board of Direct Taxes dated 29th March 2022, so this notice should be dropped. But the assessing officer went away with issuing the order under section 148A clause D and notice under section 148, for which the assessee filed the writ petition. When this writ petition was heard by the Honorable Bombay High Court, the court said that the assessing officer is bound by the orders of the appellate authorities and the jurisdictional high court. The court said that mere fact or mere a submission by the assessing officer that these orders are not acceptable to the revenue cannot justify non-compliance of binding jurisdictional high court decision. The court said that if such an approach will be adopted by the revenue authorities, then such a approach is a dereliction of duty and harassment of the assessee, which will result in chaos in administration of the tax laws. The court said that it is a classic case of abuse of power vested in the public officer, which in the present case is the jurisdictional assessing officer, and the present case is a case of total non-application of mind. The court said that in the present case no attempt was made by the assessing officer to consider the assessment under section 143 subsection 3 and the order of the CIT appeal. The court said that in the present case, for the reason best known to the assessing officer has not considered the facts in a healthy manner. The court said that it is a case of mechanical sanction, because even the commissioner has not applied his mind and has not seen the facts that whether the assessment under section 143 subsection 3 has already been completed or not, and in the present case the assessing officer thought it proper not to deal with the vital facts. the court said that the present case is a perfect example of absurd and unwarranted statement on the part of the revenue authorities that the orders are not acceptable to them, especially in the case when the jurisdictional high court has given its decision in the case of Hexaware Technologies Limited versus Assistant Commissioner of Income Tax, which is a 2024 judgment and which is reported in 464 ITR at page number 430, in which the court said that the JAW do not have the power to issue the notice under section 148. At the end of this video, once again I am repeating the name of the case. The name of the case is Samp Furniture Private Limited versus Income Tax Officer and others, and this case is reported in 477 ITR at page number 187, and the date of the judgment is 5th August 2024. Thank you, friends.